This video I'm going to answer a pretty common question that comes into our office, and that's, should I tell my employer if I've been charged with a crime? Now how this comes up is you get charged with a crime, you've been arrested, you've been bonded, you've hired your lawyer, and then you get put in a position where you've either taken some time off work or you feel some sort of obligation to tell your employer. And you need to start considering what are the ramifications of that. Should you do that? And if you are going to do that, how are you going to do it? Now the first and the most important piece of advice I can tell you is you need to sit down with your lawyer and talk about the facts of your case. Your lawyer needs to understand the charges in which you're charged with and the possible ramifications of those charges before you tell anyone about that, especially your employer. Because your employer also controls another aspect of your life, which is your finances. It's really, really important to sit down with your lawyer because your lawyer may tell you, hey, it does not make sense at all to tell your employer at any time. For one, it can create an additional witness, depending on the level of crime you're charged with. If you're charged with a really serious offense and you go in and tell your employer, hey, this is exactly what happened, well, now you've essentially created a witness that can come in and testify about your admissions that you made to them. So in just very rare circumstances does it make sense to talk to your employer or really anyone about a pending case. Usually the only time that you will ever get the go-ahead from your lawyer to talk about an offense with your employer is if it's a really low-level violation in which the state of the city would not go out and try to get admissions from an employer. Things like a DUI, maybe a simple battery, marijuana possession, things like that. There are the few instances in which you're going to get the go-ahead from your lawyer to disclose it to your employer. So again, you need to listen to your lawyer because him or her knows about the specific facts of your case, knows about the seriousness level, and knows whether their state is going to go out and try to get witnesses that you may create, like disclosing things to an employer. So that's the first thing. If you've made the decision, you've got the go-ahead from your lawyer, and you move on to the second phase, which is, okay, I'm going to go tell my employer. You need to consider a bunch of different things. And primary thing is that this may cost you your job, even if it's a minor level offense, even if your employer loves you. There might be a human resources person at the business that says we just cannot have our company exposed to any type of liability by having someone here that's accused of a crime, even a low-level offense. So you need to be prepared that if you do tell your employer that it might cost you your job. That creates another problem in that you're probably going to need money and security stability while your criminal case is going on. So you don't want to disrupt that by losing your job in the middle of a criminal case and then be facing two different problems, financial hardships and the criminal case. Probably the last thing that you need to consider if you do get the go-ahead from your lawyer, if you do decide to tell your employer about your offense, is just how you phrase it. You need to go in there and not just blurt out every negative thing that you did. You need to highlight the things you did to get out of the situation or the things you did to mitigate the situation that was going forward and minimize your involvement in it. You don't want to go into your employer and tell this fantastic story that makes you look bad and induces them to fire you. If you've been charged with a crime and you're trying to weigh out whether you need to tell your employer or whether you need to withhold that information, feel free to contact my office for some advice.